For anyone that's been watching the news recently, the notwithstanding clause does seem to have appeared again and again and again. And indeed, we are seeing a much more frequent use of this clause by provincial governments compared to, say, 10 years ago or 15 years ago. For example, just very recently, we saw the Alberta government invoke the clause twice within a matter of a few weeks. And as is the case with most situations in which the notwithstanding clause was invoked, there has been a lot of controversy and debate. With this video, I hope to argue my perspective, which is that although the notwithstanding clause is democratically valuable and that it allows for elected legislatures to check the interpretive powers of unelected courts, recent uses of the clause seem to point towards a very concerning trend. Governments seem increasingly willing to use the clause in ways that disproportionately harm vulnerable minority groups, revealing how the clause can become, if we aren't careful, a tool for tyranny of the majority. Before diving into some cases in which the notwithstanding clause was invoked, it's worth establishing what the notwithstanding clause is and how it works. The notwithstanding clause, or Section 33 of the Canadian Charter of Rights and Freedoms, essentially allows federal parliament or provincial legislatures to override certain rights that are found within the Charter. It does this by allowing legislatures to pass laws that would otherwise be shot down by the courts on unconstitutional grounds. Now, here it is worth mentioning two important restrictions on the notwithstanding clause. First, that it only applies to Sections 2 as well as Sections 7 to 15 of the Charter, meaning that it applies to fundamental freedoms such as freedom of expression or freedom of association, as well as legal rights and equality rights. Secondly, any legislation that invokes the notwithstanding clause is only valid for 5 years at a time, after which point it must be renewed or it becomes nullified. Now, the notwithstanding clause was included in the Charter of Rights and Freedoms as a compromise, because at the time that the Charter was being negotiated, several provincial leaders were concerned that it would be giving too much power to the courts and to judges to interpret the meaning of the Charter of Rights and Freedoms. And this was worrying to them because they feared that it would limit their right to implement laws as they see fit. So in order to get the provinces to agree to sign on to adopting the Charter, then Prime Minister Pierre Trudeau offered this opportunity to temporarily override the Charter as a compromise. Based on sources I found, it appears that the original intention for the clause was that it would be used only to correct instances of judicial activism that runs contrary to the public opinion. Here it is worth clarifying that judicial activism is understood as cases in which the power of judicial review is extended into ambiguous cases in which personal biases of judges are more likely to influence court findings. Such a situation is concerning as it goes against one core principle of the Canadian judicial system, being impartiality. It seems to be the case that those involved in negotiations of the Charter intended that Section 33 be used sparingly and only in cases of judicial activism. For example, then Justice Minister Jean Chrétien has been quoted as saying that the clause would be used only as a last resort to correct absurd situations. And Roy McMurtry, who also had a major role in negotiations, wrote in an essay that the clause had real merit as a, quote, balancing mechanism between the legislative and judicial branches in the unlikely event that the courts make a decision clearly contrary to the public interest. There also seems to have been an assumption that any unjust invocations of the clause would be quickly shot down by the electorate, as McMurtry also wrote that political accountability is the best safeguard against any improper use of the override clause by any parliament in the future. Now, we don't need to look very far from home to see a kind of situation that Chrétien or McMurtry seemingly were really worried about and seemingly intended Section 33 to guard against. In 2022, the majority conservative U.S. Supreme Court overturned Roe v. Wade, a landmark case that constitutionally protected the right for an abortion. Despite this, polls from that time continually suggest that while a number of state governments were making moves to ban abortion almost entirely under their jurisdictions, a majority of Americans were against the Supreme Court's decision, with one poll suggesting that as much as 2/3 of Americans wanted Roe v. Wade to be upheld. Here, we see a situation that the notwithstanding clause was intended to prevent, a situation where courts dominate how rights are understood, and a system where rights can swing dramatically depending on the philosophical leanings of the court's majority. As Geoff Callahan points out in an article in The Conversation, it's entirely possible that a judicial body will make a judgment on rights that many find abhorrent. Under a system where they wield ultimate authority over the matter, there's little recourse to challenge that judgment. One major reason Canadians are very unlikely to have to worry about such a case occurring here is because Section 33 does provide a way in which to challenge court rulings. And in this way, the notwithstanding clause serves as a check on judicial overreach. The clause in this way allows Parliament to protect the Charter from a conservative court that may attempt to restrict or rescind constitutional protections enshrined previously. This, in my view, is the best version of Section 33, as a check on judicial power that acknowledges the potential for courts to make decisions and have interpretations that pose a risk to rights enjoyed by millions of Canadians. But unfortunately and regrettably, recent uses of the clause seem to tell a very different story. While the notwithstanding clause allows legislatures to protect against court rulings that threaten to limit rights, recent uses of Section 33 seem to suggest an increasing willingness to invoke the clause more as a tool for convenience and expediency, and as a way to avoid judicial scrutiny altogether. For years, the notwithstanding clause was used so infrequently that people began to think that there was a convention forming against any use of the clause. However, beginning in 2017 and up until now, we are witnessing a significant uptick in uses of the clause. One of the most salient examples at the time that I'm recording comes from Alberta just last month in October, when the clause was invoked in response to an ongoing teacher strike. The Alberta government passed Bill 2, which sent striking teachers back to work and invoked the notwithstanding clause to shield the bill from constitutionally based court challenges. Now, whether or not you think the Alberta government was right in invoking the clause to end the strike, the concern that I have about it here is that the government invoked the clause not in response to any sort of judicial overreach, but to block the courts from having a say in the matter at all. Now, it might seem weird that I'm emphasizing court input, because as you'll recall, I previously was very critical of the courts, and while I still think it is important to acknowledge how judicial activism is a legitimate risk, and should allow us to be critical of the courts, in the words of Michael Powell, we should not be one-sided in this criticism. We need to assess the likelihood that the legislature, too, will act irresponsibly, even if it acts responsibly most of the time on most issues. The Alberta government would likely justify its invocation of the clause by saying that going to court would simply be too lengthy of a process, and they'd be right in saying this. Involving the courts would significantly prolong the strike. But to completely take court input off the table, because it's inconvenient, or too lengthy of a process, or because you don't want to even risk being challenged, that is where the danger lies. Because once the notwithstanding clause becomes viewed as a tool for legislatures to avoid unwanted scrutiny from the courts, it can quickly become a tool to oppress minorities. The two cases I have in mind here are Quebec's Bill 21 and the very recent Bill 9 from Alberta. In 2019, the Quebec government passed Bill 21, an act respecting the laicity of the state. The law prohibits the wearing of religious symbols and garments for public sector workers, such as police officers, teachers, and public servants. The law also requires that those receiving public services and those providing them must do so with their face uncovered. Many Canadians view the bill as a blatant violation of entrenched freedoms, namely freedom of religion. The Quebec legislature invoked Section 33 to block the law from legal challenges on such grounds, and those who support it maintain that the bill is needed for the state to be religiously neutral. And to be fair, the bill is worded in neutral language, being directed toward all religious symbols. However, the impact of the bill is the opposite of neutral. The act disproportionately impacts groups whose religious identity and faith is embodied through visible and wearable symbols, including Sikh men who wear turbans and Jewish men who wear kippahs. Additionally, the section of the law that places restrictions on head coverings especially targets Muslim women who wear hijabs. The second case I have in mind happened just this month. Just a few weeks after the Alberta government invoked the clause against striking teachers, the same government passed Bill 9, the so-called Protecting Alberta's Children Statutes Act, which amended laws that directly impact transgender youth in the province. One law prohibits doctors from providing treatments such as puberty blockers and hormone therapy to those under 16 for purposes of gender reassignment. A second requires parents to be notified if a child under 16 wants to change their name or pronouns at school for reasons of gender identity. The third law compels schools, colleges, and other governing bodies of amateur sport to adopt policies to ensure only those born female play in female-only leagues and divisions. These three laws were passed more than a year ago and were faced by legal challenges. For instance, the first law that I mentioned, or Bill 26, faced a constitutional challenge from the Canadian Medical Association and 3 Alberta doctors. So the Alberta government invoked the notwithstanding clause in response by amending those laws to include the Section 33. Now, the religious groups most affected by Quebec's Bill 21 make up a tiny fraction of the population across Canada and in Quebec. So the bill, with its majority support in Quebec, imposes permanent restrictions on a visible minority group. And I couldn't find any figures for the number of transgender youth in Alberta, or across the country for that matter, but some polls do tell us that transgender individuals compose an extremely small portion of the population, and unfortunately are already very marginalized. In fact, one of the Alberta doctors who challenged the province's trans legislation said that trans youth are a vulnerable group that already face significant and disproportionate discrimination, and the legislation commands physicians to stand on the sidelines and watch them suffer. Not to mention that these laws target youth, people who can't even vote, and even if they could, they are such a small minority, it is likely they would have very little political sway in an election. Yet Premier Daniel Smith's team, including Alberta's Minister of Justice, Mickey Amery, maintain that the 3 bills reflect the views of an overwhelming majority of Albertans. Seeing the notwithstanding clause used in this way, as a shield for legislation that targets openly and evidently these minority groups, that should scare us. And here it is useful to turn to Aristotle, the very famous ancient philosopher who thought of democracy as unjust, because he observed that all too often, majority rule can involve unjust treatment and oppression of minorities. Nowadays, this is known as tyranny of the majority, and it is recognized that such a political landscape can lead to policies that only benefit and reflect the interests of the majority, while marginalizing minority groups who lack the political power needed to fight back. The possibility of such a situation occurring in Canada is why we have an entrenched charter. The charter is supposed to protect minorities from powerful majoritarian governments who may want to violate rights in favor of their policies. And in my opinion, it's hard to look at what's happening in Quebec and Alberta and not say that what we are seeing there could be a tyranny of the majority. Career paths have been closed off for hijabi women in Quebec. LGBTQ rights groups are worried that as a result of prohibited access to medical treatment, transgender youth in Alberta are now more susceptible to suicidal ideation. These are real consequences, with real pain and suffering, and yet it's supposedly okay that this is happening because the majority government wants things to be a certain way. Additionally, such a situation doesn't even allow for the kind of check framers of the Charter hoped would be used in the case of unjust invocations of Section 33. Remember that they assumed that if the notwithstanding clause was used in a way that was harmful, the electorate would be there to fight back. But that does not work in these cases, not when the harmed group lacks the kind of political power to apply such pressure. These 2 uses of the notwithstanding clause, I think, are instances of majority tyranny, because both involve minority rights erosion in favor of the majority's interests. So, although the clause has a legitimate reason for existing in the Charter as a way to push back in the case of judicial overreach, the way Section 33 has been used recently is concerning and may be setting a dangerous precedent. If Quebec and Alberta can get away with treating minority rights as dismissible, then what might other provinces think? What other minority groups may be at risk? Ultimately, I think as citizens we need to be very careful and keep an eye on uses of Section 33 moving forward.